Hi, I'm Justin Baldoni, and I'm here with LUK to play Ask Me Anything Within Reason.
Hello everyone. I'm going to need to work through this fairly quickly as I've got to start work soon. It's only around 30 pages, so we can skim over some sections. That should be manageable. Let me pull it up. This just came out last night. Everything started appearing in the middle of the night, and I thought it was far too late to start reading it then, so I waited until this morning. This is the defendant's response to her motion for spoliation sanctions. She claimed they intentionally deleted messages she would have needed to make her case, as they used the Signal app without disabling the auto-delete feature. However, they did disable it as soon as they received her preservation notice in December 2024, after she filed the CRD complaint. Now, she seems to be trying to backtrack, suggesting they should have preserved all messages from November 2023. That doesn't make sense, as they were still filming at that time and had no reason to anticipate a lawsuit or involve a crisis PR team. It's all rather absurd. This response explains to the judge why she should not be granted the severe sanctions she seeks. She's asking for these sanctions not just here, but also regarding the Jamie Heath birthing video and the Melissa Nathan redactions, which the judge previously denied. Essentially, she wants the jury to accept her claims as true and prevent the defendants from testifying against her. Allegations quite extreme. Lively seeks the harshest sanctions available under Rule 37E, including an adverse inference that an August 2024 crisis management strategy was not only planned but executed, and a preclusion order preventing the defendants from presenting any evidence that could refute her claim that they executed a plan to manipulate online discourse to defame her and damage her career. She is claiming a mere $300 million in damages. Her submission falls far short of the rigorous standard required for Rule 37E2 sanctions, or even the lesser sanctions under Rule 37E1. In essence, the motion alleges that some defendants may have used Signal to discuss matters relevant to this litigation before the 20th of December 2024, without disabling auto-delete. Lively asks the court to assume that all 8 defendants deleted messages that might show the execution of a crisis management strategy against her during the release of It Ends With Us in August 2024, but merely assuming that evidence may have been deleted intentionally is insufficient to justify sanctions that would severely undermine the defense of 8 individuals. The first flaw is that Lively seeks blanket sanctions against all defendants without distinguishing between them. Rule 37E sanctions are personal and cannot be applied to a group without proof that each defendant individually destroyed evidence. Lively fails to show that any messages demonstrating a smear campaign were deleted by a particular defendant, or even that all defendants used Signal to communicate about her before her complaint. Instead, she indiscriminately targets all 8 defendants. She has now filed 9 sanctions motions, which is extraordinary. Plaintiff admits that it is unclear whether all defendants used Signal prior to the 20th of December. Her allegation that all defendants executed a crisis management strategy to manipulate online discourse relies solely on the fact that negative publicity about her went viral in August 2024, and therefore assumes the defendants were responsible. In reality, she cannot identify specific communications that might prove a digital campaign took place. She merely speculates that such evidence must have existed and been automatically deleted. In other words, she asks the court to accept her unproven conspiratorial theory without any supporting evidence. Furthermore, Lively refuses to acknowledge her own conduct, which triggered the public backlash following the release of the film in August 2024. Her behavior since the lawsuit began, including pursuing 107 creators over comments she disliked, clearly demonstrates how she contributed to the destruction of her own reputation, which she then attempted to shift onto others. Finally, Lively fails to meet the critical threshold for Rule 37E, which requires showing that any defendant anticipated litigation over a smear campaign, the alleged subject of the deleted communications, and thus had a duty to preserve such evidence before her complaint was filed on the 20th of December 2024. That doesn't make any sense, because Melissa Nathan wasn't even involved at that point, nor was Jed Wallace, who has now been dismissed from the lawsuit for the second time. Lively's claims essentially fall into 2 categories. First, allegations of sexual harassment and gender discrimination by certain Wayfair defendants between the 15th of May and the 14th of June 2023. And second, claims relating to an alleged digital or smear campaign supposedly initiated in August 2024. The Signal messages at issue in the plaintiff's motion pertain solely to the alleged digital campaign, not to her sexual harassment claims. She does not attempt to show that any party anticipated litigation over a PR strategy or digital campaign when the purported Signal messages were deleted. Any such deleted messages, if they even existed, would be irrelevant, as they would not concern a PR or smear campaign, given that no crisis PR efforts were underway at that time. Plaintiff only references a demand letter dated the 9th of November 2023, related to objections she raised in 2023, and the defendant's discovery response, which confirmed that in November 2023 they anticipated litigation in connection with the filming in May and June. 2023, Lively fails to demonstrate that defendants could reasonably have foreseen litigation in which signal messages from August to December 2024 would be relevant, and therefore fails to establish any duty to preserve those messages. She also fails to demonstrate any prejudice arising from the defendant's actions, a prerequisite for sanctions under Rule 37E. In fact, Lively herself admits that she was not prejudiced by the deletion of signal threads, noting that substantial evidence exists demonstrating that the alleged retaliatory campaign was implemented as planned. She has also produced multiple expert reports, relying on the evidence she provided, albeit erroneously, to opine on the execution of the digital campaign. Since she has substantial evidence that the campaign occurred, she cannot show prejudice arising from the purported denial of additional evidence, which may be considered cumulative. Without a showing of prejudice, sanctions under Rule 37E are not warranted. Lively thus fails to establish any entitlement to sanctions. Even under subsection E1, which covers less severe sanctions, she does not meet her burden. Instead, she seeks the more severe remedies of an adverse inference and preclusion under 37E2. Without satisfying the threshold under E1, she cannot access E2 sanctions. Even assuming she did meet E1's requirements, she fails to show that any defendant intentionally deprived her of evidence for use in litigation, a necessary condition for the more severe E2 sanctions. Speculation and conjecture are insufficient to justify sanctions, let alone severe measures like an adverse inference or a presumption that damaging evidence existed and was deleted. This is just one of multiple sanctions motions in which Lively implicitly concedes that the evidence obtained in discovery will not support her claims and instead seeks to exclude evidence crucial to the defense. Attempting to cripple the defense of 8 defendants to avoid proving claims with admissible evidence is not a proper use of Rule 37E. Plaintiff also spends considerable time arguing that defendants were slow in producing documents or otherwise obstructed discovery. The defendants deny these accusations, and any perceived shortcomings in their discovery efforts are irrelevant to a Rule 37E analysis, as the court cannot impose spoliation sanctions under its inherent powers. Turning to the factual background, Lively asserts claims for sexual harassment and retaliation under Fiajan and Title VII, as well as defamation and reputational harm against the Wayfair defendants. She further alleges that Wayfair's public relations and crisis management team, including Jen, Al, Melissa, Nathan, and Tag, orchestrated a digital campaign that manipulated negative content against her online. During the first phase, Lively complained about alleged mistreatment on set by Baldoni and Heath, including conduct that made her uncomfortable, ranging from wardrobe and scheduling issues to comments from Baldoni about her appearance in costume for an intimate scene. She also objected to Heath showing her a video of his wife after giving birth in connection with filming a birthing scene, which sounds entirely absurd. Lively did not file a formal complaint but raised her concerns with Baldoni, Heath, and others, including the film's distributor, Sony. During the strike-related pause in filming, the Wayfair defendants received a letter from Lively's lawyer, Lindsay Strasberg, demanding that Wayfair implement a 17-point list of protections as a condition for her return to complete the film. The letter stated that if the production did not uphold these protections, Lively was prepared to pursue her full legal rights and remedies. Lively now attempts to argue that this letter served as a preservation notice, implying that the defendants should have disabled Signal's auto-delete function and saved all communications. In my opinion, that interpretation is unreasonable. The letter does not explicitly threaten litigation or require preservation of all communications. The letter stated that if Wayfair were unwilling to accept the protections, Lively might pursue other options. Under extreme financial pressure to complete the film, and with pressure from Sony, Wayfair agreed to the protections. The Wayfair defendants understood that this agreement resolved the Phase 1 issues and removed any threat of potential litigation. Filming resumed on the 5th of January 2024 following a tense all-hands meeting on the 4th of January, during which Lively's husband Ryan Reynolds spent hours berating the Wayfair defendants for their conduct. After returning to set, Lively made no further complaints, and there is no evidence that the Wayfair parties failed to uphold the agreed protections during Phase 2 of filming. The PR defendants were not parties to these protections, did not attend the 4th of January meeting, and had no contact with Lively regarding her prior complaints. During the second phase of production, Lively sought to seize control of the production, taking charge of editing, post-production, and marketing. Ultimately, she gained control over the entire post-production process. Lively accomplished this through threats that she would not participate in marketing the film if her demands were not met. Despite being contractually obliged to do so, she did not even threaten legal action at this point. Not content with usurping Baldoni's role as director and excluding him from marketing the film he developed, financed, directed, and starred in, she then barred him from the premiere, refused to be photographed with him, and demanded that he and his guests be hidden from sight. There are photographs showing Baldoni and his guests in a separate screening room. He was also excluded from publicity photos and promotional appearances, and Lively publicly unfollowed him on social media. by the time of the film's premiere. On the 6th of August, rumors of discord on set were circulating in the press and on social media. These were driven by Lively's own actions, such as unfollowing Baldoni and insisting that he be stripped of credit for the film. The decision was particularly tone-deaf given the public sensitivity around alcohol-related issues, yet Lively promoted her Betty Boo's alcohol products at events. The public backlash was immediate and severe. Essentially, she caused the controversy herself, leaving the PR team to manage only routine monitoring and defensive measures. Given Lively's hostile conduct, the Wayfair parties were understandably concerned about potential negative publicity. On the 25th of July, they contacted Melissa Nathan and Tag to defend against Lively's anticipated attacks and protect the film and Baldoni's professional reputation. They also retained Jed Wallace for digital monitoring. On the 2nd of August, the crisis management team circulated a scenario planning document outlining a proposed strategy to counter negative press and Lively's disparagement of Baldoni and Heath. Lively characterizes these defensive measures as a retaliatory smear campaign and alleges that the Wayfair parties engaged in a sophisticated and well-financed plan. In reality, the Wayfair defendants were merely defending themselves and Baldoni against negative publicity generated by Lively's own conduct. Lively herself implicitly concedes that the PR effort was not retaliatory but aimed at protecting Baldoni's reputation. The strategy described in the scenario planning document was never implemented. Anti-Lively and pro-Baldoni sentiment went viral organically. Lively's own timeline demonstrates that the defendants could not have orchestrated the spikes in negative publicity on the 8th and the 14th of August. The first spike occurred on the 8th of August, prior to Wallace's retention, and only a day after Nathan referred him. Even the 14th of August spike cannot be explained by any PR intervention. Turning the entire internet against Lively in under 2 days would have been impossible for the defendants. These facts undermine Lively's presumption that the defendants manipulated the online response regarding the use of Signal after the crisis management team was engaged. But before Lively filed her claim on the 20th of December, certain defendants communicated using Signal, a widely used secure messaging app. Seritz, Baldoni and Abel did not use Signal at all during the pre-litigation period to discuss Lively, despite her claims that messages were deleted. Where Signal was used, the auto-delete feature was active. Defendants also used traditional communication platforms, such as text messages, which have been produced and contribute to the substantial evidence Lively relies upon. Lively filed her CRD complaint on the 20th of December and issued a cease and desist notice regarding a litigation hold on the same day. Defendants promptly disabled Signal's auto-delete function. Non-privileged Signal communications after the 20th of December have been produced. To establish spoliation sanctions under Rule 37E, a party must demonstrate 1. That the party with control over the evidence had a duty to preserve it at the time it was destroyed, 2. That the evidence was destroyed with a culpable state of mind, and 3. That the destroyed evidence was relevant to a claim or defense such that a reasonable fact could find it supportive. Sanctions under Rule 37E exist at 2 levels. E1 sanctions, available upon a showing of prejudice and limited to measures necessary to cure the prejudice, and more severe E2 sanctions, including adverse inferences and terminating sanctions, which require proof that the evidence was destroyed with the intent to deprive the other party of its use in litigation. Rule 37E sanctions are personal. The destruction of documents by one party cannot justify sanctions against another. Lively fails to identify which of the 8 defendants may have deleted specific Signal messages. Her assertion that all defendants used Signal to discuss matters related to litigation is in fact, there is no evidence that most defendants used Signal pre-litigation, let alone to communicate about Lively or to delete relevant evidence. Lively concedes that pre-litigation Signal threads were primarily used by Nathan and Wallace, and admits that it is unclear whether Baldoni and Sarewitz used Signal before the 20th of December. Baldoni only used Signal in relation to a men's support group, and Heath briefly connected with Wallace but left no messages, evidencing a plan to manipulate online sentiment. Abel did not use Signal pre-complaint except for matters unrelated to this case. In some instances, the plaintiff fails to demonstrate that any particular defendant used Signal during the pre-litigation period, let alone deleted evidence showing that the public relations strategies outlined in the scenario planning document were implemented. Yet the blanket sanction she seeks would effectively strip all 8 defendants of the ability to defend against her claims of retaliation and defamation. To establish that Rule 37E applies, a party seeking spoliation sanctions must show that the party in control of the evidence had a duty to preserve it at the time it was destroyed. Lively contends that Strasbourg's the 9th of November demand letter put the Wayfair defendants on notice of potential litigation and that the evidence was relevant to such litigation. She also cites defendants' interrogatory responses acknowledging that Wayfair recognized the possibility of litigation relating to the filming. However, this only pertains to anticipated litigation over her Phase 1 objections. There was no basis to foresee any retaliatory smear campaign or PR strategy-related litigation in mid-2024. In other words, any pre-litigation threat concerned Lively's harassment claims, not the alleged digital campaign. Lively's motion assumes that deleted signal threads may have been relevant to the execution of the digital campaign rather than her harassment or discrimination claims. She provides no evidence that any party anticipated litigation over a PR strategy or digital campaign when signal messages were deleted. It is unreasonable to suggest that defendants could have foreseen litigation in November 2023 over a campaign that would not exist until August 2024, nearly a year later. The threat of litigation over her harassment allegations dissipated once the Wayfair defendants agreed to the protections, which expressly resolved the issue. Lively identifies Nathan as the most frequent Signal user, retained in August 2024 as a crisis manager. There is no evidence that, prior to the 20th of December, Nathan had reason to anticipate litigation relating to her activities on behalf of Wayfair. She was hired to respond to anticipated backlash from filming, not to prepare for a lawsuit over a PR campaign that had not yet occurred. Nathan was not involved with Wayfair in 2023 and had no knowledge of Strasbourg's the 9th of November letter or the nature of Lively's complaints. There is no evidence linking Nathan or Tag to any duty to preserve evidence at that time. Rule 37E requires proof that evidence existed and was destroyed. Speculation or assumption that signal messages may have been deleted is insufficient. Lively's motion asks the court to presume that defendants deleted signal chats showing execution of the PR strategy, but speculation alone cannot justify sanctions. A showing of prejudice is also essential. Lively claims that deleted communications may have demonstrated the digital campaign and that her ability to prosecute her claims was impaired. Yet, on the first page of her motion, she admits there is already substantial evidence showing the campaign was executed. She does not explain how the absence of further evidence prejudices her claim. Courts routinely exclude cumulative evidence, and she cannot establish prejudice here. Lively fails to show that any defendant acted with a culpable state of mind. The Signal's auto-delete feature was disabled after litigation commenced, and post-filing messages have been produced, undermining any claim of